challenges experienced by the defendant, it was difficult for his accounts with the defendants to be audited for over 2 years. That on the 28th of May 2018, he was requested to meet the internal auditor of the defendant for reconciliation of the defendant's customer-debtor ledger spanning between 1st of January 2016, excuse me, to 31st of June 2018. And that through the reconciliation and adjustment of the account, the money on his ledger was reduced from 5,836,662 naira 70 kobo to 4,116,362 naira 70 kobo. The claimant grouses that his salary was stopped from May 2018 without a formal complaint, query, or allegation. The claimant further alleged that based on the complaint filed by the defendant, he was arrested by the police on the 25th of July 2018, and that on the 27th of July 2018, he got an email from the defendant titled, I quote, suspension without pay, end of quote, alleging that a case of fraud has been established against him at the police station. The letter of suspension was tendered in evidence as Exhibit C4. The claimant further testified that his salary before his suspension was 60,000 naira and alleged that from the time of his employment, the defendant had been deducting the sum of 3,840, being 8% of his monthly salaries, purportedly as remittance to his pension fund administrator. According to the claimant, the defendant's contribution is 10% in the sum of 4,800 naira. The claimant's statement of accounts with pension trust fund was tendered in evidence as Exhibit C6. While answering questions under cross-examination by the learned defendant's counsel, the claimant testified that the reconciliation of his accounts was conducted on the 22nd of June 2018, together with one John Dogo, the head of Sales North, that a report was made, and, at the end of the reconciliation, stated that the sum standing to his credit was 5,836,962 naira 70 kobo. But after some adjustments, reconciliation, the amount was reduced to 4,116,362 naira 70 kobo. The claimant also testified that a list of the customers that were owing was given to the defendant and denied that he is indebted to the defendant for the sum being alleged in the counterclaim. DW1, the regional manager, and DW2, the internal manager, in their testimonies confirmed that a reconciliation of the claimant's accounts as a sales executive of the defendant was conducted sometime in May 2018. Both witnesses admitted that the claimant's salary was stopped during the pendency of the reconciliation of his accounts. According to the witnesses, it was discovered during the reconciliation of the claimant's account that a total sum of 5,836,962 naira 70 kobo, being value of the product sold by the claimant, was unremitted, but that after reconciliation, a balance of 4,116,362 naira 70 kobo still wasn't unaccounted. The witnesses alleged that the claimant sold the defendant's products but failed or refused to remit the proceeds to the defendant, and denied that the defendant has a policy that allows the salesman to sell goods on credit to non-accredited customers. The witnesses testified further that the claimant and his guarantor requested for time for the repayment of the money, that when they refused or failed to repay the money, a complaint of fraud was lodged against the claimant at the police station. The bail was granted to him upon his promise to repay the money, but rather than paying the money as promised, the claimant instituted this action. The witnesses maintain that the claimant is indebted to the defendant for the unremitted accounts. The reconciliation summary of accounts was tendered and admitted in evidence as Exhibit D1. Both witnesses further testified that the defendant does not have any dispute with the claimant's trust fund pension and denied owing the claimant the sum being claimed. Now, the task the court is to undertake is to examine the evidence on record as adduced by the claimant in order to determine whether or not the evidence has satisfied the requirements of proof imposed by the provisions of Section 131 and 132 of the Evidence Act 2011 as amended to substantiate the claimant's claim as endorsed in paragraph 28 of the statement of facts. By my understanding, the grounds of the claimant is that Exhibit C4, that by Exhibit C4, he was placed on suspension without pay for 3 months on the ground that a case of fraud in the sum of 4,116,362 naira 70 kobo had been established against him, but the suspension was made without compliance with the procedure for discipline of staff as provided in defendant's employee handbook. The claimant further contends that the defendant refused to pay his salaries for the period of the suspension until date. It further alleges the defendant had failed to remit monthly deductions made from his salaries and that he has thereby suffered untold hardship by the action of the defendant. As can be gleaned from the evidence on record, there is no dispute between parties that in May 2018, the claimant's salary was stopped pending the reconciliation of his account and that he was suspended from the services of the defendant on the 27th of July 2018 for 3 months. Parties are also adding that after the reconciliation and adjustments of the claimant's account, the sum of 4,116,362 naira 70 kobo was unaccounted for. The defense advanced by the defendant is that, except for few accredited customers that have credit facilities, the claimant was engaged as sales executive to sell the defendant's products on cash, but that the claimant had sold the products but without remitting the money. However, the claimant denied being indebted to the defendant in the said sum and maintained that he sold the products to the defendant's customers. The submission of learned defendant's counsel in his written address is that parties in civil suits must prove their cases on preponderance of evidence and balance of probabilities. That's where a party fails to discharge this burden, then the opponent need not prove any facts, and the party alleging cannot rely on the weakness of the opponent's case. Learned counsel argued that the claimant was placed on suspension without pay pending the determination of the reconciliation of his account and police investigation into his case, but that the police investigation was stalled when the claimant rushed to institute the present action. Learned counsel further submitted that the claimant has not discharged the burden to be entitled to his claims. The cases of Ayoride and others versus Shokuru and others, Benedict Ojukwu versus Chinyere Ojukwu, and Okoye and others versus Nwako were cited to buttress the submission. Now, Exhibit C4, the letter of suspension, dated the 27th of July 2018, is crucial in the determination of the issue at hand. I've taken liberty to reproduce the relevant portion as follows. I quote, "The case of fraud was established against you in the sum of 4,116,362 naira 70 kobo. This case was reported to the police and the investigation is ongoing. Accordingly, you are hereby suspended from work without pay for 3 months with effect from 27th of July 2018. End of quote. As I earlier stated, the case of the claimant is that the defendant did not issue a formal complaint, query, or grievance before a suspension and thereby failed to comply with the provision with the procedure as prescribed in Exhibit C5 that is the employee handbook. However, the evidence on record in paragraphs 10, 11, and 12 of the statements of facts is that on the 28th of May 2018, a meeting was requested by the defendant for reconciliation of accounts of the claimant. The testimony of the claimant is further that after some adjustments, the money accounted for was reduced from 5,836,962 naira 70 kobo to 4,116,362 naira 70 kobo. While under cross-examination by Leonard Defendant's Counsel, the claimants testified further as follows, I quote, on 22nd of June 2018, I carried out a reconciliation of sales account with head of sales North, John Dogo, and internal auditor, Emmanuel Issa. At the end of reconciliation, a written report was signed by the above stated persons and myself. The amount standing to my credit was 5,836,962.70. Thereafter, after some adjustments and reconciliations, amount stood at 4,116,362.70. End of quote. Had undertaken a careful perusal of Exhibit C5, the employee handbook as it relates to disciplinary action. It is stated at page 47 thereof as follows, I quote, if an employee is found guilty of an act of misconduct or unsatisfactory performance that does not in itself warrant termination of employment, management may in its discretion apply various disciplinary actions as set out below. End of quote. One of such disciplinary actions is stated at page 48 is suspension from duty. By Exhibit C5, a quote, an employee may be suspended from duty without pay for up to 2 weeks or 10 working days. End of quote. An employee on suspension may, where practicable, be required to report each working day for 2 hours to an official designated by the group. They will be paid half their basic salary and transport allowance for the period of the suspension. End of quote. Now, suspension is defined as a temporary relief of the duties of an employee for a definite or indefinite period with a view of allowing the employer conduct investigations on allegations of misconduct or any other breaches made against an employee. It is in accord with judicial decisions in business practice to suspend an officer being investigated from the place of work to permit unhindered investigation to be carried out and also to allow peace to reign at his place of work. There are both foreign and local judicial decisions approving suspension of an employee pending the final determination of his involvement in the allegations leveled against him. The period of suspension is to keep such person out of further mischief and provides as employer further time for reflection or rumination. Excuse me. A brief exposition of the law as to suspension may not be out of place. The learned author, E.M. Rao, in the book Industrial Jurisprudence, a critical commentary, LexisNexis Butterworth, New Delhi, India, 2008, variously discussed the ambit of the law relating to suspension. At pages 236 to 237, the learned author stated that there are two types of suspension. Quote, suspension pending inquiry and suspension as a punishment. Suspension pending inquiry is not a punishment per se, for if the employee is not found guilty, the suspension has to be lifted and it has to be paid to full wages for the period as if it was never suspended. On the other hand, suspension imposed on the establishment of guilt is in the nature of punishment. It can have adverse impacts on the career prospects of the employee within the organization. In the instant case, it is my respectful view the claimant was suspended pending inquiry or investigation. As stated in Exhibit C4, the suspension is pending the outcome of the investigation of the police, and it is for 3 months. However, the duration of suspension, of an employee as provided in Exhibit C5 is for 2 weeks or 10 working days. Undoubtedly, the defendant exceeded the prescribed period by suspending the claimant for 3 months and thereby acted contrary to the clear provisions of its employee handbook as set out in Exhibit C4, and I so hold. The defendant admitted that the claimant's salary was stopped in May 2018, that was before it was formally suspended in July 2018. Having held that the prescribed period in suspending was exceeded by the defendant, the claimant is entitled to his claim for payments of his salaries from May 2018 to July 2018 and salaries for August 2018 to October 2018 being the period of his suspension, and I so further hold.
As the court pleases.
In furtherance of the defense, the defendant's witnesses testified that the claimants promised and pleaded for time at the police station to enable him repay the amounts being claimed by the defendant, but that he filed the instant action rather than honor his promise. Learned defendant's argument is that the investigation by the police had been truncated or frustrated by the claimant and submitted that time does not run against criminal investigation and prosecution. As expressly stated in Exhibit C4, the case of fraud reported by the defendant to the police and investigation is ongoing. In that regard, investigation by the police has not been concluded. Therefore, the claimant is not entitled to reliefs 1, 2, and 3 of the claims, and I so hold. The further contention of the claimant is that monthly deductions made from his salaries were not remitted to his pension fund administrator. The defendant did not dispute the claim as averred in paragraph 13 of the statement of defense that it has no dispute with trust fund pension. The submission of learned defendant counsel is that payment of pension contribution is regulated by Pensions Reform Act 2014 and further argued that the act does not mandate employers to pay pension to employees, but the same is payable to employees' administrator. Although learned counsel had rightly stated the position of law as it relates with the payment of pension by employers to the pension fund administrator, his argument on the claimant's claim for remittance is beside the point. The claimant's grievance is that, the defendant has refused and or failed to remit his contribution to his pension trust administrator and tendered in evidence Exhibit C6 in proof of his claim. Now, Section 57 sub A of the Pensions Reform Act Supra imposes the duty on the pension fund custodian to receive the total contribution remitted by the employer on behalf of the pension fund administrator. By this section, remittances are by the employer. As such, the defendant in the instant case has the burden to prove that the contributory pension of the claimant has been paid. See the case of Ong So Min Nigeria Limited versus Hoff, 1992, 4 Nigeria Weekly Law Report, Part 238 to 673. The defendant witnesses testify that the defendant does not have disputes with trust fund pension, but failed to discharge the burden that the said contribution had been remitted to the claimant's fund administrators. On the claim of 5 million naira for exemplary damages in the case of Central Bank of Nigeria versus a code year 2015-14 NWLR Part 1479, that's page 231. The Apex Courts laid down the principles guiding the award of exemplary damages thus. High Courts, exemplary damages are awarded with the object of punishing the defendant for his conduct and inflicting injury on the plaintiff. They can be made in addition to normal compensatory damages and should be made only: 1. In a case of oppressive, arbitrary, or unconstitutional acts of the government servants. B. Where the defendant's conduct had been calculated by him to make a profit for himself, which might well exceed the compensation payable to the plaintiff. And 3. Where expressly authorized by statute. At page 263, the Apex Court stated further, I quote, for exemplary damages to be awarded, it need not be specifically claimed, but facts to justify it must be pleaded and proved. Thus, once facts in the pleading support the award of exemplary damages, the court should award it, since the adverse party is in no way taken by surprise. Furthermore, since rules of courts nowhere say that exemplary damages must be specifically claimed, it can be granted if facts are pleaded and evidence led to justify it. See also the case of Nursing and Midwifery Council of Nigeria versus Ogu and another, 2019 Law Pavilion Electronic Law Reports at 53899. From the totality of the facts in this case, the claimant did not plead facts and failed to lead evidence to justify that he is entitled to this claim for exemplary damages, and I so hold. In the final, the claimant's claim succeeds in part, and for the avoidance of doubt and abundance of clarity, judgment is hereby entered for the claimant in the following terms: an order directing the defendants to pay to the claimants the sum of 360,000 naira only, be unpaid salary for the months of May 2018 to July 2018, and salaries for August 2018 to October 2018, the period of the suspension. 2. An order directing the defendants to remit the claimant's pension to trust fund pension, the claimant's pension administrator. Now, to the counterclaim. As the defendants discharge the burden of proving its entitlement as it claimed, as correctly submitted by Lani Claimants Counsel, there is no doubt that a counterclaim is a separate and distinct claim from the main claim. This is so because even if the main claim fails or is withdrawn or struck out, the counterclaim will survive. To put differently, the same standard of proof required to prove the main claim is also required to prove the counterclaim. See Attorney General of Lagos State versus Attorney General Federation, Ogoli Oko Memorial Farms Limited and another versus Nigeria Agricultural and Cooperative Bank Limited and another. Citation supplied. See also the case of Falomo versus Onahami, 2015, 11 NWLR, Part 935 at 126, cited by Lani Claimants Counsel. The defendant's claim claims the sum of 4,116,362.70 kobo, being value of defendant's products allegedly sold by the claimant but failed or refused to remit the proceeds to the defendant. In proof of the claims, Exhibit D1, the summary of reconciliation of accounts of the claimant was tendered in evidence. The claimant testified in his defense that the money was with the defendant's customers who collected the goods on credit, that he was threatened and forced to admit owing the sum of money being claimed, and maintained that he is not indebted to the defendant for the alleged amount. This fact was, however, denied by the defendant in paragraph 2 of its reply to the claimant's defense to counterclaim. Now, by Section 13171, Evidence Act 2011, the standard of proof in civil cases is on the preponderance of evidence or the balance of probabilities. This rule simply means that the evidence adduced by the claimants should be put on one side of the imaginary scale, and the evidence adduced by the defendants put on the other side of the scale and weighed together, not by the number of witnesses called by either side, but evidence of probative and qualitative value to see which side preponderates. See Magaji versus Odofi, 1978, for Supreme Court at 91, where the Apex Court held that preponderance of evidence has to do with the evidence that has the most convincing force, and it is sufficient to incline a fair and impartial mind to one side of the issue rather than the other. See also Jack versus White, the case of Okori versus Unkalaba, and another citation supplied. Exhibit D1 was tendered in evidence by the defendants to prove its claim. The claimants also made reference to the said exhibit in paragraph 10 of the statement of facts, and then acknowledged in paragraph 12 of the statement of facts that the money was reduced from 5,836,962.70 kobo to 4,116,362.70 kobo after the reconciliation of the accounts with DW1. While under cross-examination, the claimant admitted that he signed Exhibit D1 together with both DW1 and DW2. Excuse me. I am of the firm view. The defendant has proved that the claimant is indebted in the said sum and therefore entitled to his claim, having been found to be meritorious, and I so hold. Judgment is hereby entered in respect of the counterclaim in the following terms. 1, the claimant, defendants to the counterclaim shall pay to the counterclaimant the sum of 4,116,362 naira 70 kobo, being the value of the products of the defendant's counterclaimants. It is hereby further ordered that the defendant's counterclaimants shall pay the said sum set in one above within 30 days to the defendant's counterclaimant. Parties shall bear their respective costs. This is the court. Here?
Yes, my lord. I
Yes,
sincerely apologize. Hello?
Yes, I can hear you.
My lord, I sincerely apologize for joining late. My name is Abdullahi Badaruddin,
Okay.
for the claimant.
Yes, thank you.
I want to thank my lord for the judgment.
So do we have station, please? Sorry, I can't hear you. What?
You know,
Yes, my lord.
but no case online. The defendant stands up, but he's not saying anything.
Is it muted?
He's
Hello, my
not.
lord.
Yes, sir.
With profound respect, my
Mr.
lord, I am.
Inoake, are you online? I've recorded him as being online, as being present. So as it is, I will have to transmit the judgment probably by the end of next week, so parties can apply, please, for whatever course.
As the court pleases.
Thank you. Yes, can I have?
Yes, number two. Yes, number 2023 between Kabir and you, Adeniyi. And one, also Emirate Council, two, secretaries also Emirate Council, three, Ministry for Local Government across the United States, and four, Sabon District. So back district heads. Fellow parties absent.
Parties absent, appearances, please.
Appearances, my lord, with profound respect and humility, I am you always.
Yes.
My humble appearance is for the applicant, my lord.
For the applicant.
Yes, my lord.
Yeah. Any representation for the defense? Yes. Ruling. The claimant was employed as the village head of Kurujufi village. Mr. Ways, how do you call that village?
Kurungufi, my lord.
Okay, thank you. The claimant was employed as the village head of Kurungufi village of Turawa town, Zoba local government area of Kaduna state. His case is that the defendant breached his contract of employment by terminating his appointment without complying with the terms of his appointment and public service rules. He alleged that all efforts made to the defendants for his reinstatement had proved abortive. As a result, the claimant instituted the present action by originating summons filed in this court on the 18th of May 2023, wherein he posed two questions for determination for the court as follows. One, whether the defendant has powers under the chieftaincy law of Kaduna State to terminate the employment of the claimant without consultation with the State Civil Service Commission and without regard to the provisions of Chieftaincy Law of Kaduna State and the Constitution of the Federal Republic of Nigeria as amended. And two, whether under the Public Service Rules 2009, the claimant is still a valid and subsisting employee of the defendant. Upon the determination of questions set out in the foregoing, the claimant thereby claimed against the defendant the principal reliefs set out as follows. We have four of the reliefs as stated in the face of the ruling. I skip it to save the time of the court. The originating summons is supported by an affidavit of 12 paragraphs, into which two documents were annexed as exhibits. Also filed in opposition, the defendants filed 33-paragraph counter affidavit deemed filed on the 12th of October 2023, to which was attached a written address of learned counsel. The claimant's case is very simple and straightforward. He was employed by the defendants as the village head of Kurugufi village in Turawa town, Zuba local government area of Kaduna State, by letter of appointment dated the 21st of January 2002, that is Exhibit A. And according to him, a salary was reviewed and upgraded by the defendants over the years. Attached to the affidavit in support of the originating summons as Exhibit B as credit notification of the claimant's salary of April 2023. The claimant contends that by Exhibit Exhibit C, his appointment was terminated by the second defendant on the 7th of March 2023. The claimant alleged the defendant breached the terms of his appointment and the public service rules in terminating an appointment, and that all efforts made to the defendant for his reinstatement has proved abortive. See the depositions in paragraphs 2, 4, 5, 7, and 11 of the affidavit in support of the originating. In reaction, the defendants in their counter affidavit contend that the appointment of the claimant is probationary and was subject to confirmation by the first defendant. That upon an allegation of misconduct, the claimant was invited by the fourth defendant, and the claimant admitted that he committed the allegation. The defendant contend that due process was complied with in terminating the claimant's appointment, that termination of appointments of village heads is not conducted by the Civil Service Commission, but by the Emir or Chief on the recommendation of district heads and with the approval of the third defendant. The defendants maintained that the claimant was given opportunity to be heard before his appointment was terminated and denied that the termination of the claimant's appointments was in violation of public service rules and chieftaincy law. The defendants further contend that the claimant's termination is not unlawful and that he is not entitled to his claims. From my appraisal of the facts set out in the foregoing, the question that seems to me to have a reason for resolution in the present suit can be distilled as follows: whether the claimant clearly established that the termination of his appointment by the defendant was unlawful to entitle him to the reliefs being sought. Whether the termination of the appointment of the defendant was wrongful to entitle him to the reliefs being sought. In determining this issue, I should state that taking cognizance and benefits of the totality of the written and oral arguments canvassed by respective learned counsel, and as I proceed with the judgment, I shall endeavor to make specific reference to the submission as I deem needful. It is, of course, the law which has its foundation in Section 131 of the Evidence Act 2011, that it is the party who asserts that bears the burden of proving that the facts which he asserted are in existence. It is needless to cite authorities for this well-known principles. It is equally settled law that in an action for wrongful termination and employment, the claimant has the duty to place before the court the terms and conditions. The contract's condition of service is the bedrock upon which an aggrieved employee must found his case. It succeeds or fails upon the terms thereof. Now, as gleaned from the contents of Exhibit A, the appointment of the claimant is probationary for 3 years, after which he will become eligible for confirmation by the Emirate Council. It is equally imperative to note that apart from stating his salary, no other condition or conditions of service was stated in the said exhibit. The courts have been enjoined not to look outside the terms stipulated or agreed by parties in deciding the rights and obligation of parties. A court will determine the terms of the contract and the rights of the parties thereto from the terms of the agreement, which is binding on both parties. See the cases of Afribank Nigeria PLC versus Oshisoya, Oloruntoba Oju versus Abdurrahim, and Umar Swen versus University of Benin. Citation also applied. As correctly submitted by learned defendants counsel, it is not the duty of employer to prove the terms of the agreement allegedly breached and prove in what way the terms were breached by the defendant. The onus is always on the claimants to prove this. In the cases of Moron Folu versus Kwara Tech, and the case of Kato versus CBN, citation supplied. In the present case, the claimant did not place before the court the conditions of service. He claimed the defendants breached or the manner the breach occurred. It was stated expressly in Exhibit A that his confirmation of appointment is by Emirate Council, not by the public service rules. This failure to place before the courts the conditions of service is fatal to claimant's case. In other words, the claimants have failed to prove that he is entitled to his claims. And I so hold. I should express the view that the claimants, having opted to commence the suit by originating summons, seem to have restricted the quality of evidence that ordinarily could have availed him. The claimant's contention is further that he was neither queried or given the opportunity to be heard before his appointment was terminated, but did not prove this. As it is, only pleadings could have resolved this issue, but no, lawyers want shortcuts, hence originating summons. The point is that in Adeniyi versus APC and others, citations supplied, relying on National Bank of Nigeria versus Alakija, citation supplied. It was held thus, I quote, the principle has become trite that the originating summons procedure is not for causes in which facts remain hostile and in conflict. The procedure is ideal for the determination of short, straightforward questions of construction and interpretation of documents or statutes. It is never the applicable procedure in controversial cases where the facts on which the court is invited to construe and interpret the document or legislation is in relation to remain violently in conflict. End of quote. Here also in this regard, the cases of Fanfare Oil Limited versus AG of the Federation and another case of Engineer Ezegwe versus Chief Benson Chooks, Nwalu and others, citations supplied. In choosing to come by way of originating summons, the claimant delimited his case to the question posed, the facts presented. The matter must thus be resolved within the limits of the claimant's affidavit's evidence. By law, commencing an action by originating summons instead of a complaint does not imply that the competent must be restricted to the issues raised in the originating summons. In fact, this I hereby resolve the question set down in the instance of originating summons against the. My decision is therefore that the action lacked in merit and in substance. It shall be, and is hereby accordingly dismissed. Parties shall bear their respective costs.
As the court pleases. My Lord, we are grateful for the sound ruling of the court, and we pray for more wisdom to the court. We stand to be guided, my Lord, and we are rightly guided by the just ruling of the court, my Lord. Thank you, my Lord.
Thank you, sir. The ruling will be ready for collection if you want a copy by the end of next week, please, because in Abuja I'll have to find a way of transmitting the signed copy to Kaduna.
The court pleases, my Lord. Thank you, my Lord. Have a nice day.
I wish you the same. The court will rise, please.
Court.